stop everything you are doing right now. Put down your phone, pause whatever is playing in the background. Because what happened at the Supreme Court of the United States in the last 24 hours is the kind of decision that comes along once in a generation. And the people who understand it first are the ones who benefit from it most. Mainstream media is already downplaying this. Some outlets are ignoring it entirely. And that is not an accident. Because what 6 justices of the Supreme Court just did cuts directly against the narrative that gun restrictions are legally untouchable, politically permanent, and constitutionally acceptable. They are not. And the court just said so, clearly, 6-3. Hit subscribe right now and turn on notifications before we go any further, because I cover every major Supreme Court development on Second Amendment rights in plain language, no spin, no political agenda, just the legal reality you need to know. And you cannot afford to miss what is coming next, because this decision is the beginning of something much larger, not the end. Here is exactly what happened. Here is what it means for you, specifically, in your state with your firearms. And here is the word-for-word script to use if law enforcement or any government official tries to enforce a restriction that this ruling just put on very shaky legal ground. Let's go. Why this moment has been building for decades. To understand why this ruling is so significant, you need to understand the legal war that has been fought to get here. Because this decision did not come out of nowhere. For most of the 20th century, courts treated the Second Amendment as a second-class right, a collective right tied to militia service, rather than an individual right to keep and bear arms. That interpretation gave federal, state, and local governments nearly unlimited authority to restrict firearms without serious constitutional challenge. Magazine bans, carry prohibitions, weapon classifications that banned entire categories of commonly owned firearms, all of it upheld again and again. Then came Heller in 2008. The Supreme Court established for the first time that the Second Amendment protects an individual right to keep and bear arms for self-defense. It was seismic. But it came with a massive asterisk. The court said some regulations were still permissible. And lower courts spent the next decade using that asterisk to uphold virtually every gun restriction they reviewed. Then came McDonald in 2010, extending Heller's protections to state governments. And again, lower courts found ways to limit its practical impact. Then came Bruen in 2022, the most significant Second Amendment decision since Heller. The court established a new test for evaluating firearms regulations, requiring the government to justify any restriction based on the historical tradition of firearm regulation at the time of the founding. It specifically rejected the interest balancing test that lower courts had been using as a tool to rubber stamp gun restrictions. Bruen was a genuine turning point. But here is what happened after Bruen. States like New York and California did not comply in good faith. They looked at the ruling and immediately started building workarounds. New York passed the Concealed Carry Improvement Act within weeks, dramatically expanding the list of sensitive locations where carrying is prohibited, effectively turning most of the state into a carry-free zone. California followed a nearly identical playbook. New Jersey, Illinois, Maryland, all of them found creative ways to maintain the practical effect of their restrictions while nominally acknowledging Bruin. And lower courts, particularly in the Ninth Circuit and the Second Circuit, continued to uphold many of these restrictions despite Bruin, using narrow readings of the historical tradition test to justify outcomes that looked remarkably similar to the outcomes they had been reaching before. Gun owners won at the Supreme Court and then watched those wins get slowly absorbed and neutralized in the circuits that matter most. Today, that cycle hit a wall. What a 6-3 emergency decision actually means. Let me break down the specific legal significance of what just happened, because the details matter and almost no one in mainstream coverage is explaining them correctly. The Supreme Court has 9 justices. A 6-3 decision is the strongest possible majority with the current court composition, representing all 6 conservative-leaning justices voting together. When that coalition holds, it sends an unmistakable message to every lower court in the country. This is not a close call. This is not a narrow ruling with room for creative interpretation. Apply it. But the emergency nature of this decision is what makes it extraordinary. An emergency decision, sometimes called emergency relief or an emergency application ruling, is issued when the court determines that waiting for the normal appellate process would cause irreparable harm to constitutional rights. The standard for granting emergency relief is high. The court has to conclude that the lower court ruling being challenged was not just wrong, but likely wrong, and that allowing it to stand, even temporarily, causes real, immediate, ongoing harm to real Americans. Think about what that means in practice. The Supreme Court looked at what a lower court allowed to remain in effect, looked at the Second Amendment rights of American gun owners being restricted under that ruling, and said, this cannot wait. The harm is happening now. We are stepping in now. That is the court sending a signal that goes far beyond the specific facts of this case. It is 6 justices saying to every lower court, every state legislature, every attorney general who has been finding creative ways to maintain gun restrictions after Bruin, we see what you're doing, we are not satisfied, and we are not going to let it continue without intervention. That signal is itself a form of legal protection, because every actor in the firearms legal landscape, prosecutors, state officials, local law enforcement, lower court judges, now knows the Supreme Court is watching and is prepared to act. The 5 areas of gun law this decision hits hardest. Let me walk through exactly where this ruling lands with the most immediate and significant impact, because it is not limited to one state or one type of restriction. Area 1, assault weapon bans. Illinois, California, Maryland, New Jersey, Connecticut, Massachusetts. Every one of these states has an assault weapon ban currently being challenged in federal court under the Bruin standard. Those challenges have had mixed results in the lower courts. Some have been successful, others have been upheld. A 6-3 emergency decision from the Supreme Court reinforcing Second Amendment protections strengthens every single one of those pending challenges by signaling clearly that the court takes them seriously and expects lower courts to decide them consistent with Bruin's historical tradition test. The legal argument that weapons in common use meaning weapons that millions of law-abiding Americans own for lawful purposes, cannot be banned under the Second Amendment, just received powerful support from the highest court in the country. Every attorney handling one of these challenges woke up today with a stronger case than they had yesterday. Area 2, magazine capacity restrictions. California's 10-round limit, New Jersey's 10-round limit, New York's restrictions, Colorado, Hawaii, Maryland, all of these are facing active legal challenges. The argument that magazines in common use cannot be restricted was already significantly strengthened by Bruin. A 6-3 emergency decision reinforces that argument and puts fresh, undeniable pressure on lower courts to rule accordingly. The circuits that have been most aggressive in upholding these restrictions now have the clearest possible signal that the Supreme Court disagrees with their approach. Area 3, carry restrictions in sensitive locations. This is the area where states have been most creative in their post-Bruin resistance. By expanding sensitive location lists to cover schools, government buildings, public transit, parks, restaurants, bars, entertainment venues, and in some cases, virtually any privately owned business open to the public, states like New York and California recreated their struck-down permitting systems through location restrictions instead. You technically have a permit, but you have nowhere legal to carry it. Those location restrictions are being challenged in multiple circuits right now. This decision adds significant weight to those challenges and puts pressure on lower courts to apply Bruin's historical tradition test rigorously, rather than finding sensitive location exceptions broad enough to swallow the rule. Area 4, federal firearms prohibitions. Several federal prohibitions on firearms possession are working through federal circuits under Bruin challenges. The domestic violence restraining order prohibition, certain conviction-based prohibitions, elements of the federal gun-free school zones law, the Supreme Court's willingness to issue emergency relief in a Second Amendment case signals to every federal circuit that these challenges deserve serious, rigorous review, not the kind of reflexive deference to government interests that characterized the pre-Bruin era. Area 5, ATF regulatory actions. Ghost gun rules, pistol brace classifications, frame and receiver redefinitions, bump stock regulations. Every ATF regulatory action currently being challenged in federal court benefits from every Supreme Court signal that the Second Amendment is a genuine constitutional right that agencies cannot regulate around through administrative rule changes. The major questions doctrine, established in part through the Cargill bump stock decision, already limits what the ATF can do unilaterally. Today's decision reinforces the broader principle that unelected agencies cannot expand firearms restrictions beyond what Congress has clearly authorized. What anti-gun states will do and why it does not stop you. I want to be completely honest with you here, because you deserve accurate information, not just a headline that gets you excited and then leaves you confused about what actually changed. States that want to maintain their restrictions are not going to look at this decision and immediately comply. That is not how this works, and it never has been. They're going to pursue 3 strategies simultaneously, and you need to understand all 3. Strategy 1 is narrowing their laws. State legislatures and attorneys general will examine exactly what language the decision uses exactly what facts it rests on, and they will redraft the restrictions to fall just outside the specific ruling while maintaining as much of the practical effect as possible. This is what happened after Bruin. New York did not repeal its carry laws, it rewrote them. California did not end its magazine restrictions, it defended them with new legal arguments. Expect the same response now. Strategy 2 is delaying enforcement changes for as long as legally possible. Procedural motions, appeals to circuit courts, requests for stays, arguments that the ruling does not apply to their specific statutes, every tool available to slow the practical implementation of a Supreme Court decision will be used. Some of these delays will last months, some will last years. Strategy 3 is arguing that this ruling simply does not require them to change anything. Every state's laws are slightly different, and state attorneys general will claim that the Supreme Court's decision addresses a different factual situation than their own laws present. They will require lower courts to specifically apply the ruling to their specific statutes before they change anything voluntarily. None of this is cynical speculation. It is the documented pattern of how states respond to Supreme Court decisions they disagree with. And knowing the pattern is what allows you to navigate it effectively. Here is what matters for you practically. The window between a Supreme Court decision and a state's successful workaround is a real window. It is open right now. During that window, restrictions that were previously being enforced with full legal confidence are now legally uncertain. Prosecutors making charging decisions are aware of that uncertainty and factor it into their calculus. Defense attorneys handling firearms cases have arguments today that they did not have yesterday. And the organizations filing follow-on challenges in every circuit are moving right now while that window is open. The people who move quickly and strategically in this window are the ones who benefit most. Which brings me to exactly what to do. The exact words to use if someone cites a restriction against you. This section is critical. Memorize these lines before you need them, because needing them and not having them is the worst possible situation to be in. If a law enforcement officer, a range officer, a government official, or anyone else tells you that a restriction this ruling may affect still applies to you, here is exactly what you say. I am aware of the Supreme Court's recent emergency decision on Second Amendment rights. Before I accept that this restriction still applies in its previous form, I want to confirm its current legal status with a firearms attorney. Can you provide me with the specific statute you are referencing? That response does three things simultaneously. It signals that you know your rights, and you know what just happened legally. It creates no confrontation and gives the official no basis for escalation. And it puts the burden exactly where it belongs, on the person citing the restriction to identify the specific legal authority they are relying on. If they tell you nothing has changed, you say this: I understand that legal implementation takes time. I'm going to consult with a Second Amendment attorney about how this decision applies to my specific situation. Until I have that guidance, I'm going to assert my constitutional rights while remaining completely respectful and law-abiding. And if they ask whether you know about the decision, you say, yes, I'm following it closely. I believe it significantly strengthens the legal standing of constitutional challenges to several current restrictions, and I'm already in contact with a firearms attorney about how it applies to me. These are not confrontational statements. They are legally grounded, professionally delivered assertions of rights that the Supreme Court of the United States just reinforced with a 6-3 majority. You are not defying anyone. You are doing exactly what the legal system asks of you, asserting your rights through proper legal channels while remaining calm, polite, and law-abiding. Always remember that you assert your rights through attorneys and courts, not through confrontation. The system just demonstrated with a 6-3 emergency decision that it is capable of protecting your rights. Use that system. Your complete 48-hour action plan. Here is exactly what to do starting right now. Action 1. Contact a Second Amendment attorney in your state today. Ask them specifically, how does this decision affect the restrictions currently applicable to me in my state? Many firearms attorneys are doing consultations on exactly this question right now. Do not wait until next week. The window is open today. Action 2. Contact your state's major Second Amendment organization, the Virginia Citizens Defense League, the Illinois State Rifle Association, the California Rifle and Pistol Association, the Texas State Rifle Association. Whatever organization is most active in your state, they are already mobilizing legal resources in response to this decision. They need your support and you need their information. Action 3. Stay informed through legal analysis, not just news headlines. The practical impact of this decision will be determined by what happens in federal courts over the next 6 to 18 months. Following legal commentary from Second Amendment scholars and constitutional attorneys, not political commentators, is how you stay accurately informed through the transition rather than getting excited by headlines and then confused by the reality of slow legal implementation. Action 4. Document any restriction currently affecting you. If you are prohibited from carrying somewhere you believe you should legally be able to carry, if you own a firearm or accessory that is classified differently in your state than this ruling may require, document it now. Date, location, specific nature of the restriction. This documentation may be directly relevant to a legal challenge that provides you relief. Action 5. Support the organizations doing the legal work that turns Supreme Court wins into actual change. The Firearms Policy Coalition, the Second Amendment Foundation, Gun Owners of America, the NRA Institute for Legislative Action. A Supreme Court decision is the beginning of the legal process, not the end of it. The follow-on litigation in every circuit, every state, every challenge statute is funded by people who understand that constitutional rights require active defense. A win at the court creates the opportunity. What you do with that opportunity determines what it actually means for your life. The bottom line, a 6-3 emergency decision from the Supreme Court of the United States is not a procedural footnote. It is not a narrow ruling that applies only to one person in one state. It is 6 justices saying in the clearest possible terms that Second Amendment rights are real constitutional rights, that they are being violated, that the violations are causing immediate, irreparable harm, and that the court is not going to wait for lower courts to fix this on their own slow timeline. The legal landscape changed today. Restrictions that were being enforced with full confidence yesterday are legally uncertain today. Challenges that were uphill battles yesterday have a stronger foundation today. And attorneys, organizations, and informed gun owners who move quickly in this window are the ones who translate a Supreme Court decision into actual change in their states, their counties, and their daily lives. Stay informed, stay connected, stay legal, and do not let the states that want to ignore this decision succeed in doing so, because the court just made very clear that it is watching, it is prepared to intervene, and it is not satisfied with how lower courts have been treating your Second Amendment rights. If this video helped you understand what just happened and what to do about it, hit subscribe right now. Turn on notifications. Share this with every gun owner you know, because they need this information and they are not getting it from mainstream media. I will see you in the next one. This video is for educational and informational purposes only and does not constitute legal advice. Laws vary by state and individual circumstances differ. Always consult a licensed attorney for advice specific to your situation.